Now, the next topic is, as we discussed yesterday, uh, that a criminal case can be filed by any Tom, Dick, and Harry. The jurisdiction, the locus standi to approach the criminal court is very wide, whereas the locus standi of the plaintiff to approach a civil court is very narrow. So we will discuss the various cases and circumstances as to how, who can file the civil cases, who can file the criminal case, and who cannot. Because the FIR can be filed by anybody. There is no bar. By the victim, by or any person who is familiar with who is aware of the commission of the offense. Section 154 doesn't tell you that you cannot lodge a FIR. You can lodge it, provided you are a person having knowledge about the commission of the offense. Similarly, whereas a civil suit can be filed under the law by an agreed person. Suppose you are a person who wants to evict your tenant, you are a landlord, you have to file it, or somebody on your behalf, you can give a power of attorney, isn't it? Under the provisions of Order 3, who are the parties, the appearance is given there. Appearance can be in person or through duly constituted attorney. So I mentioned to you the circumstances under the Code of Civil Procedure. The doctrine of locus standi, namely to file a suit, is limited. Normally, an agreed person files it. A person who would like to have relief from the court of law files it. Say, for example, you have been dispossessed by the defendant without following the due procedure established by law. So you file a suit under Section 6 of the Specific Relief Act, either for a summary suit, for restoration of possession, or under subclause 2 of Section 6, both for substantive suit for declaration that you are the owner of the property, you have been dispossessed, your illegal possession is illegal, and consequently for restoration and for injunction, other orders. So similarly like this. But there's one type of matter, there are couple of two type of matters which I mentioned to you under the provisions of Section 88, which speaks of interpleader suit. Please note that. What is interpleader suit? When you open Section 88, देख लीजिए आप CPC खोल लीजिए Section 88. Where two or more persons claiming adversely to one another the same debt, sum or money or other property, movable or immovable, from another person who claim or no interest thereon other than for charges or costs, and who is ready to pay or deliver it to you, the rightful claimant, such other person may institute a suit or interpleader against the claimant for the purpose of obtaining a decision to the person to whom a payment or delivery should be made, and for obtaining indemnity for himself, provided that where any suit is pending in which the right of parties can be properly decided, no such suit of interpleader shall be instituted. So Section 88 embraces two situations, namely, an interpleader suit can be filed by a person against two or more persons. Like a finder of a good under the Contract Act, I gave you an example. In the Government Law College, I found a ring where 3-4 students are claiming that it belongs to me. So I am not supposed to return to anybody. I have a right to either hand it over to the principal or file a suit, interpleader suit, for a declaration to whom does it belong. The court may pass an appropriate order. It belongs to A or B or C or D. So interpleader suit can the declaration is sought, but in which I do not have interest. At the most, only I am entitled to the cost. The plaintiff is entitled to cost. and he is not seeking any relief from the court. That's procedure for filing a suit under Section 88 is given under the provisions of Order 35, which is a supplementary procedure. Please read Order 35 of the Code of Civil Procedure. Yeah. Order 35 में देख लीजिए यहाँ पे. Yeah. In every suit for interpleader, the plaint shall be, in addition to the other supplement necessary for the plaint, namely, the person claims interest in the subject matter in dispute for charges. The person claims no interest. Normally, in a plaint, the plaintiff says that he is entitled to ownership of the property. He is the owner of the property. He has entitled to easement right. He is entitled to damages. He is entitled to so and so. In a easementary matter, in a interpleader suit, he clearly mentioned he has no interest in the subject matter. Then the claim made by the defendant is severely and there no collusion. So there are more than two defendants are claiming ownership of the property. Then there is no collusion. You have to mention in the court proceeding in the plaint, there is no collusion between the plaintiff and defendant. The plaintiff is not representing any of the parties, but the goods which is sought to be delivered are being claimed by defendant 1, 2, 3, 4, 5, which this honorable court may please to determine who the real owner is. That is the subject matter. So ultimately no. So there is no real interest in the matter. Now the second category of suit under the Code of Civil Procedure is a representative suit. Please open Order 1, Rule 8 CPC. Order 1 खोल लीजिए आप. Order 1, Rule 8. You should know that one person may sue or defend on behalf of all in the same interest. Where there are numerous persons having same interest in one suit, one or more such person may, with the permission of the court, sue or be sued, or may defend the suit on behalf or benefit of all the persons so interested. The court may direct one of the more such person. So this provision says that according to this provision, normally this is you may call it a public interest litigation type. Like a fundamental right petition under Article 226, the poor people are unable to move the court of law for enforcement of fundamental right. Under Article 32, you can approach Supreme Court. Under Article 226, the High Court. The slum developers case, the Bombay Footpath Association's case, and many people, they are entitled to the Olga Telly's case, where all journalists, reputed journalists, filed writ petition for enforcement. Then Mr. Mehta's case in the environmental ecological imbalances, but MC Mehta cases are very famous. All of you know in the first year student. He filed several cases, cleaning the Ganges, cleaning Jamuna, cleaning the rivers, cleaning so many parks. So those are all writ petition for enforcement of fundamental rights or for enforcement of statutory duties of authority. But this is CPC does not speak of fundamental rights or statutory implementation, but civil rights. For adjudication of a civil right, a civil suit would lie and not a writ petition would lie. So can one person sue on behalf of himself, on behalf of others? Yes, way back in the year 1906 when the CPC was enacted, this provision has been there from the very beginning. So, for example, I give you the municipal corporation giving a 351 notice for demolition, or the provisions of Mahada, the notice is given for vacation, mass movement, everybody. Maybe in a chawl, in a society, building, cooperative society. See, one person can sue on behalf of everybody for a declaration that the notice which has been issued by the corporation or the defendant is illegal. Because there is no need to file so many cases. There need not be multiplicity of proceeding. To avoid this is an option given by in the CPC. One person may sue with the leave of others, And one person may also defend on behalf of the other. So this is in the nature of a public. That the condition precedent here is this, under order 1 rule 8, the plaintiff who files a representative suit, he must have interest in the suit. Please note that. He must have interest, and the person on whose behalf he is seeking to contest, they must also have interest in the suit. Unlike the earlier suit, that is which we learned right now under section 88, interpleader suit, where the plaintiff has no interest. Here in the order 1 rule 8 suit, that is called representative suit, plaintiff must have interest. If he doesn't have interest, he cannot file it. But then there are the other suits in the CPC, all other suits. You know that. I'll just give you brief history. A summary suit under the provisions of all civil suits are adjudicated by leading evidence. There must be a plain, there must be a written statement, isn't it? Then uske baad, then the parties are at liberty to, they had to exchange their documents, they exchange interrogatories, they file list of documents, then the court frame the issues on the basis of the pleading, plain, written statement, interrogatories, affidavits, all material and record under order 14. वो होने के बाद, then the trial takes place in the CPC, which is a role of Evidence Act come into play. Then under order 18 rule 1 CPC, right to begin of the plaintiff start, who should start. Then the provisions of section 101, 2, 3, 4 by Evidence Act is put to service. Then examination chief, cross-examination 137, 138 of the Evidence Act read with order 8 rule 1 is coming to play. Then cross-examination under 138 and section 45, 46 come into play. We'll deal with it later on. So it's a very lengthy procedure. Civil suit is a lengthy procedure, but there is one exception in the code of civil procedure. There is a summary suit under order 37 rule 1 and 2. Zara CPC खोल लीजिए आप, order 37 rule 1 and 2 के लीजिए. In this, Evidence Act role doesn't come into play. You did not go into the box. Merely production of document come into play. So please open order 37 rule 1 and 2. (37) rule 1 and 2 summary suit, which is filed on the basis of the hundis, the bounce checks. Order 37 rule 1 and 2. Classes of suit, it can be filed in high court, city civil court, and small causes court depending upon the valuation. Up to 25,000 small causes court, up to 1 crore city civil court, after 1 crore above unlimited the high court. So this suit is filed on the basis of promissory note. See that here. Then recovery of net, liquidated damages, and bounce check. Amount must be accepted by the parties, not disputed. Summary procedure. Here the defendant as a matter of right has no right to file written statement. He has to ask for permission. When a suit is filed, the plaintiff must serve the writ of summons upon the defendant. That if the defendant must seek the leave, appearance within 10 days. When you see order 37, institution of the suit, order 37 rule and 2, filing of the suit, 33 के अंदर defendant का appearance है, within 10 days he must appear before the court. Please note that here. Within 10 days, order 37 rule 3 subclause 1 के अंदर, he must take leave of the court to appear, and intimation देना पड़ेगा other side को, plaintiff को, I have filed appearance. Once he gives appearance before the file within 10 days, then plaintiff is at liberty to take out summons for judgment. In the summons for judgment, he will take out an application placing on record the defendant has no defense. He is wasting the time of the court by filing appearance. And this honorable court be pleased to pass a decree by passing a decree, power to pass a decree in the matter here is the application of the plaintiff. Do you see that here? 37, 4, 5, 6, 7 के अंदर procedure पढ़ लीजिए आप, then I will again बाद में later on explain. This is I am coming shortly for the purpose to show that the difference in. Then the leave of the defendant seeks a leave to file written statement. Leave of the, he can leave, he can seek the court, please grant me permission to file written statement. They are triable issues. The suit is barred. The claim is fictitious. I not signed the check. These are vicious. Or triable issue, if the court is convinced, the court might say that deposit some money, 50% full money, then we'll see later on. If the court is granting, if the court is convinced the defendant has a case, they'll grant leave. Otherwise, court will straight away pass a decree in the matter. So there is no escape. Immediately decree is passed, in which event the defendant has no say in the matter here and no evidence is taking place. You need not go for examination, chief re-examination. List of documents are filed in the matter. Notice given, check bounce given, and promissory note given here. That is a shortcut procedure is adopted under the provisions of Order 39. Then CPC speaks of other types of suit. I'll just give you a brief summarily. Under the provisions of the general suit is filed. There are in the Bombay High Court, we have got, summary suit is number one. Then we have got regular suits. We have got regular suits which are filed in various proceedings. Then special suits are filed. Testamentary suits are filed here. Then against these are the private suits. Then against the government, there are suits, special suits against the government of Maharashtra, Union of India, central government. That is the procedure is under section 79 and 80 of the Code of Civil Procedure. When you see, please open section 79 and 80. There are special suits against the government. Open section 79. Suit against the government. Section 79. If you want to file a suit against the government, you have to give a first 2 months notice under section 80. If notice is not given, suit is bad. But if you're obtaining certain urgent orders, injunction order, some urgency is there, the requirement of notice can be dispensed with by making an averment in the plain. That notice may kindly be dispensed with. 80 sub clause 2 check karo aap. Section 80 sub clause 2 ke andar the relief against the government, which may mention that this honorable court be pleased to dispense with giving up the notice. The court can dispense with the notice. Dispensing karne ke baad, then you have to comply with the procedure of giving notice under section 2 after notice is over. So this procedure, section 79, 80 and order 27 khol lijiye aap. Please, you have to connect this with the order 27 too. Order 27 khol lijiye. Order 27, sued by against the government or public in picture. Now, what are the procedure? What kind of a plaint you are required to file? Whom you should join the party? You cannot join the minister as a party. You cannot join the president or prime minister. You have to join the Union of India. You padhe humne article 311 वगैरह में पढ़े ना 311 में 311 that follow procedure. Is procedure prescribed? Please read section 79, section 80 and order 27 clearly for one type of a suit against the government. Then CPC also contemplate suits when you see 79 ho gaya, then open section 83 suit against aliens. Okay, 83 check karo aap. When aliens may sue, against how the aliens can be sued here. People who are not citizen of India, enemy country, if you want to file who are aliens, this procedure is under section 83. When foreigner state may sue the matter. Suit against rulers, 85, 86 procedure. These are all special suits. And 85, 86, yes, remember rakhe yahan pe, is very important. 85, 86 is very important. Suit against foreign rulers, 84, 85 and A. Then suit buyer against the soldiers, sailors. That procedure will be under order 28. 28 में आ जाइए आप. What procedure you have to follow for filing a suit against in the matter 27 के बाद 28 में आ जाइए. 28 suit against yes, yeah. Then 27A also speaks of a suit involving substantial question of law to the interpretation of the constitution or validity of a statute. It is not only writ petition under Article 226 or 32 is filed for challenging the validity of any act. Even people who are living in villages and towns, they who cannot come to the court, they can file in district court. These suits can be filed under 27A के अंदर चेक करो आप. Suits can be filed for deciding the constitutional validity of any act enactment. Then 28 speaks of suit against military and naval people. The procedure is followed. Then what kind of a procedure? What is the requirement? Then suits against corporation companies is under order 29. Procedure. The company, you have to file a suit against the company, registered office or unregistered office, but by virtue of section 20 sub explanation A, even a regional office you can file a suit, because we have mentioned to you that unlike the Companies Act, explanation to section 20 say that suit can be filed against even a subordinate office of a company. You need not file it against McDonald's in USA. You can file in branch offices Bombay, Calcutta, Madras, जहाँ पे भी है इसके अंदर. Suppose you want to file a suit, section 20 explanation check करेंगे आप. You can file it against the company, even a branch office, a subsidiary office is it. That is section order 19. Then 30 speaks of suit against firms and there are partnership firms, where the partners are required to be joined, when to be joined, when not to be joined, when not joined, when the court tells you to join them, because partnership firm is not a legal entity unlike the company. Whereas the company you can sue in its name, it has a seal, it's a legal entity. But whereas a partnership company, you learned under the Partnership Act and Companies Act, it is not a legal entity. So you are required to join the partners in some cases where the court may insist partners, because one partner is acting in a fiduciary capacity against the other. Their interests are mutual. The properties of a property can be attached and they are actionable, and one partner is accountable to other partner unless the deed of partnership speaks otherwise. You know that here, disclosure of name. Then suits against co-partner ho gaya. Then we learned right now 31 suits by against trustees or executors is order 31. Suits when a suit is filed against a private trust, public trust, under the Bombay Public Trust Act, you cannot file a suit without the permission of the Charity Commissioner. Please note that section 51. When it's a private trust under the Public Private Trust Act, you can file a suit against trustees. You must join all the trustees because the trustees are representing the estate of the trust in a fiduciary capacity. Certain public trust under the public trust, the suit is never barred under section 10 of the Limitation Act. But you have to take care to join all the trustees in the matter, whether it's a public trust or a private trust in the matter. Then 33 अभी हमने पढ़ा अभी minors के बारे में, isn't it? Right now we learned under order 33 suits against a minor, how it is filed. We learned. Then order 33A speaks of suit relating to matters of concerning family matters. Family dispute. Suppose wherever there is no family court, city like Bombay, Calcutta, Madras, they have family court. But there are small towns and villages, there are no family courts. You can file a matrimonial suits under the provisions of order 32A. Please note that district areas, they do not have family court. And I don't think Thana has got a family court. Pune has got it. But places like Satara, Gitara, all these places, they don't have it. small places. So the suits against the family people are filed under 32A. When proceedings are held for divorce or family matter, husband and wife, relation, anybody challenging the question, legitimacy of children, custody of children, they come under this. Whereas in City of Bombay, is the Family Court Act, Guardian and Wards Act, there's the Juvenile Justice Act. So various legislations are come into play, and the proceeding before the court are held in a camera proceeding. See that section order 32(2) से कहता है 32 proceeding. Now otherwise generally under the CPC the proceedings are all in the open court. That proceeding, that section I will tell you under the Code of Civil Procedure how the court proceedings are required to be in the open court. That you may kindly see the provisions of section 153. Check karo aap. If I am not mistaken, it is 153. Yes, 153B. Check karo. Place of trial to be deemed to be open court. Under the CPC, it is a trial, has to be an open court unless the court otherwise feels that camera proceedings are required. Camera proceedings are required mean certain proceedings which are held, divorce proceeding, custody of petition, rape proceeding in CRPC. Under the CRPC, the analogous provision is section 327. 327 CRPC खोलिए जरा. 327 CRPC. See, court proceeding to be open 327, but when you see subclause 2 के अंदर 327 subclause 2 proceed inquiry with regard to offences under 376, 376 all rape cases, offences affecting the modesty, outraging the modesty of women or held in camera. Please see 327 subclause 2. Remember this, and also proceeding subclause 3. The court shall not publish them. 327(3) के अंदर no publication is allowed. याद रखिए. Though section 327 say that open court में होना चाहिए. Generally all proceedings are in the open court. 327 CRPC and section 153B of the Code of Civil Procedure. Now family court proceedings under the CPC order 32(3) mandate that proceeding shall be in camera proceeding. Okay, the family proceeding का detail दिया गया है. So please note that you are invoking section order 32A wherever there is no family court. Please note that. Then the suits by indigent person, order 33, the 33 mean persons were unable to pay the court fees. Merely because you are a pauper, you do not have money. In the state of Maharashtra in Mumbai city, maximum court fees is 3 lakh, which is very steep. A poor man who has been devastated in storms and who has become bankrupt, who is unable to pay court fees, whose parents are dead in accident. Garib aadmi, he may be having property. Some trespassers have trespassed into property. A minor may not be having money. He can make an application to the court. My suit be tried as an indigent person, as a soma pauperis. That provision, please read properly, is a suit of a pauper under order 33 of the Code of Civil Procedure. Is a very important step in this direction, 33 ke andar. Then we learned yesterday, also today, order 34 speaks of suit relating to mortgages of immovable property. That is suit for redemption, suit for foreclosure, suit for sale, which we discussed, which I will not again repeat it. Then under order 35, interpleader suit, abhi discuss ki humne, I won't be. Then order 36 ke andar, there are special cases filed for seeking the opinion of the court in any matter. Parties can tell the court here, we would like to seek opinion on the custom. A particular custom followed in a particular community is correct or not. Because custom suit, because under the Evidence Act, when you see that here, evidence of a custom can be led by parties to prove a particular custom. That is, please open section 13 of the Evidence Act. Section 13 kholo aap. Yeah, section 13 of the Evidence Act khol lijiye. Facts relating to right or custom in question. You can introduce fact with regard to customs under section 13. Then under section 32 of the Evidence Act, 32 कहते हैं देखो, a person expert evidence can be taken into consideration for proving a custom. Please see that here. Section 32 आप चेक करें, subclause 7, a document relating to transaction mentioned in section 13, where the statement contain will or a document relating to transaction mentioned 13A, that can be proved by way of a dying declaration of a person, dead person. Then another suit, expert opinion on the basis of the customs. You can see the opinion. Section 45, 46, 46. Then 49, 50. They're all opinion of the court with regard to custom relationship between the parties. They all can be proved. They can be invoked here in these cases. So such suit also would lie here in the matter. Then opinion of the court can be sought under the provisions of Order 36, whether a particular custom exists or not, whether a particular easement is there or not, whether a particular what you call it, particular immovable property, get a movable property. Various questions can be caused by the court, by the parties themselves, by framing before the court of law. Then, of course, 37 Rule 1 में अभी हमने check किया summary suit of the proceeding, where check bouncing cases, other cases. So various rights of cases are filed under the provisions of the Code of Civil Procedure. This you learn, like yes, family matters पढ़ लिए, yes. These are the various suits. Then you have special suits also under the CPC, public nuisance suit, law section 91 के अंदर. When the public nuisance is committed, you can request the Advocate General. See section 91 खोल लीजिए आप. Section 91 में, Section 91 के अंदर public nuisance suit, Advocate General can file it, or with the leave of the court, 2 or more persons. Some processions are taking place during examination of the student. You can halt the procession which are causing nuisance. Okay, 91. 92 can the public charities, like big institution like Sai Baba Temple or Haji Malang Dargah or any other Dargah or any other temple, any church are being misused by the trustees. You can come to the civil court under section 92 after following the proceeding for removal of the trustees, appointing new trustees, vesting. Though these powers are also there under the provisions of the Bombay Public Trust Act, but under the CPC general provision, the civil court powers are not taken away. Please note that this is very, very important chapter on this point here. Then, of course, there are proceedings under section 89, arbitration proceeding, conciliation, judicial settlement of Lok Adalat, mediation, dispute. So the court is not trying a dispute as a civil matter. The court can tell the parties after settlement of the issues, before the issues, it is a mandatory under Order 10 CPC to tell the parties you go for arbitration, go for conciliation, go for Lok Adalat, go for mediation. That is a mandate laid down under section 89 CPC, which is very, very important, which you all should know. Yeah? Then suit relating to trust पढ़ लिया हमने आपने. Okay. These are the, apart from the suits under the Specific Relief Act, where you seek a declaration under section 16, under section 20, then under section 6 for eviction, then injunction under 36, 37, 39, and 42. They're all various suits of perpetual order of injunction. They are not mentioned, but Specific Relief Act में देख लीजिए आप. Specific Relief Act में you file a suit for declaration for cancellation of a document, isn't it? You have studied Specific Relief Act. You file a suit for a declaration that the document is valid, subsisting, and binding of the parties. Okay. Then you produce documentary evidence. When documentary evidence is not there, not clear, you can request the court to lead oral evidence under section 91, 92. That is called extrinsic evidence or oral evidence to prove the contents of a oral document, the written document, which are not explicit. If a fraud is played by the plaintiff, by the defendant while executing a document, he has put a revolver over your head और बोला आपको साइन करो डॉक्यूमेंट को, अंडर फियर यू साइंड इट, and it's an agreement transferring your property to him. So tomorrow you file a suit challenging the agreement on the ground it is vitiated by fraud. Other party cannot say the written document speak for itself. When a document is tainted with fraud, when you have been executed it under intimidation, criminal intimidation, when revolver was put on your head, then naturally you have a right to lead oral evidence. He told me that if you don't sign this document, I will eliminate you and your family. So Section 91, 92 Evidence Act permits the situation where oral evidence can be given. That we'll discuss later on here. So these are the various types of suits under the Code of Civil Procedure. Now, okay. Anybody wants to ask me any question before I take up the next topic? That is the next
sir,
topic.
I have a request.
CRPC. Who can file complaint? Who cannot file the complaint?
Sir, I have a request.
Sir,
many students have asked us to not conduct lecture for a longer period of time.
Sorry, I have not put this. I'll put it here. Were you all able to hear me, by the way?
Yes, sir. Yes, sir. We are able to hear you.
I did not put my ear what do you call? I forgot to put it. Anybody wants to ask me any question?
Many people have.
Hopefully everything was clear. Give me 1 minute. क्या बोले? Pardon?
Continue the lecture more than 8:45 or 8:40 because it's really important to students to continue the lecture after that time.
Achha, shall we continue or shall we stop? Continue, na? We'll continue, na?
We can for doubt session.
Pardon?
Continue for doubt session.
Doubt session कभी रखेंगे?
अभी रख लेते हैं, उसके बाद नया टॉपिक अगले नेक्स्ट लेक्चर में.
Okay, next lecture means tomorrow, day after tomorrow. Okay.
Yes.
Yeah, please ask me questions now. Yes, everybody can ask me questions both in CPC, CRPC, whatever topic we are covered. Okay, पूछ लीजिए. Nobody is asking me any questions.
I think it was clear for everyone to understand.
How come such a long topic is so clear to you so soon? I'm very happy, that means. Surely. You want to ठीक है, देख लीजिए आप. Think it over. Anybody wants any question? So next lecture, shall I take the lecture on CRPC with regard to who can file complaints and who cannot file complaints? That topic we'll take it day after tomorrow. That is on Wednesday. Okay?
Sir, just a small thing. I'm sorry I'm late.
बोलिए.
Sir, we talked about the point where anyone can file a civil complaint on behalf of anyone. Like Civil Procedure Code has indeed having this procedure. Procedure where
civil complaint cannot be filed by everybody. Only a person agreed can file it. A person having interest. Whereas a criminal complaint can be filed by anybody. Please note that.
Okay.
Provided you are an agreed person, victim, or a person who are a witness to the commission of the crime. Please note that. Suppose you are a government law college student, you aligned from you got down from the Churchgate bound station train, Virar se aa rahe the aap. You saw a killing, fight is going on between A and B. You bowling A is killing B. Then you can go and lodge a complaint, FIR, because you are seeing with your own eyes. You can tell the police officer, I want to register FIR because यहाँ पे फाइट हो रही है, यहाँ पे खून निकल रहा है, ये प्लीज डेथ हैज टेकन प्लेस, the crime is going, commotion is taking place, that you have seen it yourself. But whereas if your property is trespassed by me, मैं कब्जा कर लिया, Your friend cannot file a complaint unless he has got power of attorney from you, or he or she is familiar with the case of the case. हाँ बोलिए.
Yes, sir. Sir, in criminal case, I am sorry I got that wrong prior to this explanation. In criminal case, if let's say the person who is not aggrieved but he is a witness to the crime is filing a case, and the aggrieved person is herself or himself not agreeing to report this case or file a criminal complaint, can that aggrieved person stop the other person from filing?
Certainly not. Aggrieved person is committing an offense under the provisions of the CRPC. If a private citizen, a citizen who knows the matter, offense is committed, it is your duty to report to the police and magistrate. Such offense has been public to give information. Section 39 CRPC खोल लीजिए आप. Public to give information of certain offenses. Section 39 में it's a mandatory duty cast upon the citizen to give report and also to arrest under section 43. अगर 43 के अंदर and section 39 के अंदर, if you don't exercise your powers, you can be arrested by the police officer under the provisions of section. Which section you know that? 172 पढ़िए आप. खोलिए जरा. Offenses, contempt of lawful authority or public servant. That is number 1. You are not discharging your duty as a citizen of India in reporting omission to section 176 IPC खोल लीजिए आप. Omission to give notice of information to public servant, legally bound to give it. Section 176 में you are committing an offense. IPC, and the person can go to jail for 1 month and fine. Please read section 130, section 36 and section 43 CRPC. It is mandatory for every citizen to report. समझे ना आप?
Yes, sir. Sir, legally it is, sir, but in a lot of real life circumstances, the reason behind not filing a case by the aggrieved person is because of pressure again, which the aggrieved person happens to bear all by himself or herself, in most cases herself. So in that, under that circumstances, so can the third party who is a witness over and above the will of the aggrieved party go ahead and file the case?
It is just not offense against the victim, it's again offense against the state. Criminal prosecution is contested by the state. It is the mandatory duty of the state to see to it that the accused is brought to the book. The victim cannot play any role. A rape matter, you cannot, victim cannot compromise it. She has no business to do that. It cannot be kosh. A murder cannot, in a murder case, it's not like Islamic law. A murderer can be given compensation. Maaf kar diya. Nahi. Under the Indian system, the murderer has to be brought to book. He should be, a due process of law must be followed. The offense is non-compoundable under section 320 CRPC. Please note that. And it is a mandatory duty of every citizen to report to the police and to the magistrate to give information about the commission of a cognizable offenses and non-bailable offenses. It is mandatory. And if it is not given, the person can be arrested. He can be prosecuted under section 176 of the Indian Penal Code and furnishing false information under section 177 IPC. Note down all these very important sections. And refusing to give wrong question is also offense under section 179. Please read the chapter in the IPC, chapter 10 of contempt of lawful authority of public servant.
Okay, sir. Thank you so much.
Please note that this is very important. Summons is issued to you by a police or a magistrate or a court. You have to answer the summons. If you don't answer the summons, you are committing an offense. You are absconding. Under 172 of the Indian Penal Code, you will be prosecuted.
Okay, sir.
A Havaldar is stopping your car, you are not stopping on the road. You are disobeying the public authority. You can be prosecuted. Something up. A criminal law is against the offense is against the state. It is not just against the victim.
Thank you, sir.
Yeah, और कुछ पूछना है?
Nothing more from my end, sir.
Nothing more from your end. Anybody else want to think over? We discuss so many civil cases, we discuss criminal matters. Think it over, some problem must have cropped up to you.
Sir, is there a difference between being an approver and being pardoned?
Approver and pardon. Pardon is granted by the magistrate under 306 and 307. Approver is a person, is the accused person, willing to cooperate with the prosecution agency and give evidence against the co-accused. Samjha na?
Yes, sir.
In which event he will not be convicted.
Okay, sir. Thank you, sir.
वो बरी हो जाएगा. But if he doesn't cooperate, he will be prosecuted. Okay? 306 and 307 CRPC may that you have to see that. Anybody has any more questions? Yeah. Tomorrow I will take the provisions of a very interesting provisions in CRPC. First, of course, CPC में बांध लेंगे.